We are live and on the record. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations, within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to this Zoom portion of today's hearings in the Appeals Court. I'm Judge Milkey. With me today are Judges Blake and Grant, and together we are your panel on the 6 cases we are hearing this morning. Our first case is Brennan v. City of Everett, 2021 P403. I would remind the parties that we have read the briefs and the record, so we're familiar both with the arguments and the facts. 15 minutes per side is not a great deal of time, so we urge you to cut to the chase to the extent possible. On the other hand, if you feel that you have said all you have to say, there is no shame in sitting down, or in this case, stopping. As one of our former colleagues used to say, if you hit a home run, you do not have to run the bases twice. And with that, I will turn it over to counsel, Attorney Mason.
Thank you, Your Honor. Members of the panel, may it please the court, my name is Albert R. Mason. I represent the City of Everett and Chief Carley. And the main thing that two main things that I would like to present to the court up front are: number one, standing was not necessarily mentioned in the beginning. I did give counsel, Attorney Solman, notice that I would be raising standing at the hearing, and I appreciate the fact that he also did not contest the Zoom hearing. But as far as standing is concerned, it's the concern that we raised is that 100% of the facts and 100% of the environment and the parties in this case are involved with collective bargaining and a collective bargaining agreement. And in this respect, the complaint, while it alleged wrongs, did not, as a matter of fact, specify damages for those wrongs. For example, to the best of our knowledge, the only damages mentioned in the complaint were: number one, overtime; number two, paid details; and number three, stress. And overtime and paid details, to the best of our knowledge, and we submitted the case law to support it, have been deemed speculative for government employees in regards to any form of remuneration as far as damages are concerned. As far as,
can I interrupt you, Mr. Mason? Correct me if I'm wrong, but aren't we here on a solitary issue, which is under the doctrine of present execution, whether or not your client, the chief, has qualified immunity? None of the other issues are before us on this appeal.
well, it was my understanding that, again, because 100% of the circumstances, facts involved the collective bargaining agreement, and again, what the chief did, if as a matter of fact, number one, the matter should have gone to a grievance procedure, which would be the primary.
This is interlocutory appeal. You wouldn't otherwise, but for the qualified immunity ruling, you wouldn't otherwise be before us at this time. So isn't our review simply limited to whether the chief has qualified immunity?
I don't believe so, only from the point of view that standing involves the fact that if damages are inapplicable, and if, as a matter of fact, 100% of the factors dictate that this matter should have gone, again, by presentment under Chapter 258, Section 4, to the city first, and it didn't, that as a matter of fact, it would be a waste of time and judicial resources to remand for everything else if, as a matter of fact, Chief Carley's issues, all of his issues should be remanded to the grievance procedure, if you will, not just the court.
I have a question about the record, and particularly Chief Carley's March 3rd, 2020 letter that is in the record at volume 4 of the record appendix, page 24. That letter is a typewritten letter that is not on any kind of Everett Fire Department letterhead, and there's no handwritten signature. It's a typed signature with the letters kind of strangely out of whack. And I'm just wondering, is that a photocopy of the letter that Chief Carley actually sent? Or is it some kind of a retyping of his letter?
Your Honor, it is not the retyping. It was the draft of the letter that was sent. Chief Carley has, since this started, retired, and I was unable to get the original. But those are the specific terms that were in the letter. Those are the actual words in the actual letter. It's the draft, if you will.
Well, as I understand Judge Wilkins' ruling, it focuses on Superior Court Rule 9A, and that he did not have before him the correct record, and that's really the thrust of his ruling. Then it doesn't appear that we have before us the letter that Chief Carley actually sent with his signature on it.
And again, I would, to the best of my knowledge, counsel for the plaintiff can basically either agree or challenge the letter, or the terms of the letter, or the draft of the letter, or its authenticity. But to the best of my knowledge, that is a draft, and the original was unavailable to me because there is a new chief there.
But we're not talking about a trial. We're talking about a motion for summary judgment in which the moving party has to get his or her ducks all in a row for it to be properly considered by the Superior Court. And at least part of what Judge Wilkins seems to be saying is you didn't do that. This was not properly put forward in accordance with Rule 9A and its specific provisions with regard to motions for summary judgment.
I can't respond to that, Your Honor, other than if the letter was inapplicable, I could only suggest that it be ignored, and then any ruling on the matter be made based on everything but the letter, because again, I would say that the letter was alleged as a warning or a threat. And if it was alleged as a threat, even if it was not submitted properly, the burden of proof as to whether or not it is a threat would not be ours. It would be on counsel for the plaintiff.
Going back to Judge Blake's question, why isn't the only issue that's properly before us whether Judge Wilkins erred in denying the motion for summary judgment with regard to the qualified immunity issue regarding the one defendant? You raise a number of other potentially interesting issues, but why shouldn't those at a minimum first go to the trial court?
Again, I would only submit on that it's a matter of reality, common sense, and logic, that if all of the facts involve what Chief Carley did, then as a matter of fact, what Chief Carley did is the basis for 100% of the complaint, because a city doesn't act on its own. It acts through its agents, and it acts through its officials. And Chief Carley did if, as a matter of fact, did not provide for a justiciable action, then there is no justiciable action for against Chief Carley and or the city. I'm sorry. Was there something else, or?
No, we're still here. The time, you have 6 minutes left if you would like to use.
Well, again, when we raise standing, it's our understanding again that standing is applicable at this time under these circumstances in any event, and the issue of standing goes to whether or not there is a justiciable claim. The issue of standing goes to the fact of if, as a matter of fact, there is a justiciable complaint or wrong, then there have to be applicable damages to match those wrongs. And whether that justiciable complaint is addressed based on for Carley, if it's just for Carley, then it has to be addressed as well for the city, because Carley is the agent and the principal actor in this matter. Plus 100% of all of these facts. The reality of this whole situation is that these parties were operating in a collective bargaining agreement. And in a collective bargaining agreement, what Chief Carley did was not in disregard of the law. Well, what Chief Carley did and what the union president Hardy did was what they do every day as a matter of fact. In other words, they complied with a
Okay, but counsel, again, why shouldn't you have to make these arguments to the trial court as an initial matter?
Well, first of all, I did make these arguments to the trial court. In other words, we did raise everything in regard, but the trial court indicated no and was moving towards a jury trial. And a jury in no way, shape, or form would be qualified to address the collective bargaining issues that are in this regard. And that's why I'm raising standing here, because standing is a jurisdictional issue that applies here as well as in the Superior Court. And standing is an issue that has to be raised, it has to be addressed once raised. And if it is addressed, to the best of my knowledge, it would apply here and there as well, and for the claim as a whole.
I think we understand the argument. Is there anything else?
I don't know if it's right, but I believe that it's logical. It's what the law provides for with the issue of standing, no matter where or when it's raised.
Okay, and anything else, counsel?
No, I guess given your concerns, that's all that I have.
Okay, thank you very much. We'll hear from Attorney Suleman, who's currently on mute.
Thank you. Thank you, Your Honors. And I will take Your Honor's suggestion, and I do not think I will need the full 15 minutes. As Your Honors have suggested, an interlocutory appeal such as this can only raise issues that are allowed to be raised under a statute or a rule that authorizes an interlocutory appeal. And it's my understanding that the issues that are authorized to be raised in this appeal are the issues of qualified immunity. The other issues, as Your Honors have suggested, must first be raised at the trial court. Even if they're denied at summary judgment, then they have to be raised at trial. I can get into the issue and our defenses to present execution.
Well, let me just press you on that though, because your brother is saying essentially that what he labels a standing argument is jurisdictional. It's not dependent on the facts. It would be a supreme waste of time for this whole trial to go forward if today we could say, looking at undisputed facts, this case should never have been brought. The potentially aggrieved party should have gone a different route through filing a grievance or what have you. What do you say to
We're
that?
going to even if we're going to take that, I mean, there's just established law that that's not the case, because a collective bargaining agreement cannot waive rights under 151B. Chapter 151B rights are personal rights. They're not collective rights. That's been established as far back as 1998 in the Blanchett versus School Committee of Westwood case, 427, Massachusetts 176 at 183. There's no question that collective bargaining agreement cannot waive individual rights to be free from discrimination. That's a quote. So, while certainly collective bargaining rights have to be considered, it's black letter law that Chapter 150B rights do not waive rights, or collective bargaining rights do not waive rights to be free from discrimination under 151B.
Is that true for the FMLA count as well?
That's absolutely true for FMLA. I don't have a statute on that, but that's absolute. I'm sure your clerk can find a case site very readily. Or if you want me to provide one today, I'm happy to, if you invite me to one, but I'll wait for your clerks before you invite.
I'm pretty sure that was your responsibility, counsel.
Yeah, yes. Well, I didn't think that was an issue in this appeal because I thought the the issues here were the qualified immunity, Your Honor. But I take your point. For the qualified immunity, I think your honors have pointed out that Carly is the defendant here. The claims against him are claims of interference with the right to be not discriminated against based on disability under Chapter 151B, Section 4, Paragraph 4A. Since at
Can I
least
actually move you to the retaliation claim? As Justice Grant brought up a very interesting question about what's in the record, but how is, and I'm paraphrasing, but how is the phrase that your client could be disciplined for any incident of concern? How is that retaliation?
So that's retaliation because he's taken protective activity, filing an MCD complaint, and then in response to that, he's been threatened with basically any discipline, regardless of for any issues of concern. Now, it's, I think, well established that.
What if the letter said any incident of concern consistent with our standard operating procedure and rules and regulations?
I think that would be a much closer call.
Okay.
Here though, it's any issue, any instances of any issues of concern, which is much vaguer and basically saying anything that comes up.
It's very broad.
Very broad.
Yeah, you appeared to.
Sorry.
You were frozen for about
okay.
5 seconds.
Okay. I was going to add, because of the temporal proximity, he just filed the MCD complaint and he's coming back to work. All those things combined, plus we have to remember the standard for retaliation is usually, I know this has not been decided affirmatively by the SJC, somewhat of an open question, but the standard for adverse actions for retaliation is usually considered to be lower. Into the First Amendment context, it's considered an action that has a tendency to chill protected activity. And here, they've threatened to discipline an employees for exercising their rights under Chapter 151B. That was established as adverse action in the Ritchie case, 60 Mass Appellate Court at 665. And it's been a standard often used in other appellate decisions. I have the Gore versus Trustees of Deerfield Academy case, 385 F sup 2nd 65 at 73, where we said at the summary judgment stage, the focus is on whether or not the retaliatory act punishes the employee for engaging in protective conduct or is designed to keep the employee from reporting discrimination. Certainly here, giving a warning that any future conduct of concern will result in discipline could be construed by a reasonable jury to be designed to keep firefighter Brennan from reporting discrimination in the future. So that's I think my response. Now, if I can return to the interference claim, since at least 2013 in the McLaughlin case, it's been clearly established that it's unlawful to interfere with an employee's right to work in an environment free of unlawful handicap discrimination. And it's been long established, according to the statute, that you cannot discriminate based on regarding somebody as disabled. Here, the facts, and it's undisputed. I mean, you have to remember the defendants admitted to all the facts in the complaint. That in March of 2019, Mr. Brennan was allegedly exhibiting some behaviors at work. He was sent out to receive an evaluation of McLean's. Now that in itself would not, I believe, clearly established, regarded as, because it's an appropriate response. But he was cleared for return to duty by McLean's. And even at that point, Chief Carley then put him out of work on leave. And that's what I believe establishes.
False information that you say that the chief gave to the person performing the fitness to return to duty evaluation.
Yes, I think that just adds further evidence, but I don't think that's even needed, because.
But what is the evidence of that?
What
was the false information?
Well, the false information is that he was the acts that he was doing at work, like standing on tables.
On the table, okay.
Yes. But again, my argument is that's sort of a addition to the regarded as, because simply by ignoring the clearance by McLean's, he is engaging in the exact behavior that 151B and the regarded as prong is designed to prevent. He's putting his own stereotypes on Mr. Brennan. Discuss the litigation. FMLA is very clear. If a covered employee requests an FMLA leave, the employer has to provide it. I mean, and then they bring their forms to the doctor and they see if they're covered or not. It's undisputed that Mr. Brennan asked for an FMLA form. They don't deny that, and it wasn't provided. That's clearly established in the law that you have to provide the form. Now it's up to us to prove the damages to that, but we've alleged damages. We've alleged that he couldn't take FMLA leave. And as a result, he was put on a forced leave against his own terms. So again, the question for qualified immunity is whether it's clearly established. And we believe that right there was clearly established, and a reasonable chief would have known it. And so I think, the law is clear there. A reasonable chief in that position would have known it. If the facts are admitted, these are the only issues on appeal. There are no other issues up for appeal. I understand the standing argument that my brother raised, but the law is in a different sense, not the qualified immunity sense. The law is clearly established that members of a union do not raise their rights to be free of discrimination.
Counsel, do you read the ruling on summary judgment here to be that the chief is not entitled to qualified immunity as a matter of law, or that the city failed to prove as a matter of law that he is qualified? He is entitled to qualified immunity.
Well,
is the issue of qualified immunity now off the table, or is it just pushed down the road into the trial?
Well, I suppose that depends on whether or not they can amend their answers, because they've admitted a lot they've admitted to the facts in our complaint and their answers. So I suppose a party, I believe, can always move to amend their answers. But if they can't amend their answers, then I'm not sure how. So the short answer to your question is I don't believe Judge Wilkins ruled definitively that they cannot, but I don't know how that would be possible. But I don't know how that would be possible with all the admissions in their answer. But no, I don't believe Judge Wilkins ruled definitively as law of the case.
Okay. Anything else, counsel? I'm not seeing any further questions from our panel. Attorney Mason, you appear to be speaking. You're on mute, but there is no opportunity for rebuttal. So you have 3 minutes if you want to use it.
No, I apologize. I am, there are no.
We are live and on the record.
Thank you very much. I am still Judge Milkey, and with me again is Judge Blake and Judge Grant, and we are the panel. We're here for the second case of the morning, Kelly versus City of Holyoke, 2020 P 1182. I would remind the parties that we have read the brief, so we're familiar with both the facts and the legal arguments. So we would urge you, since 15 minutes is generally not a great deal of time, to cut to the chase to the extent possible. At the same time, if you felt you have said everything you have to say, there is no shame in sitting down. And with that, I will turn the floor over to Attorney Strihorn. I apologize if I mispronounced your name.
Thank you, Your Honor. Good morning. May it please the panel. My name is Molly Ryan Strihorn, and I'm here for Sean Kelly. This Chapter 258 claim was dismissed during the Rule 12 pleadings, so the record is slim and the issue is narrow. The city would have you believe that it is a much broader issue that it impacts public policy and a larger class of plaintiffs, but I urge you to see it for what it is, a very discrete, erroneous misapplication of the law to these discrete facts.
Could I just ask you, did a judgment enter, a judgment of dismissal?
It did, Your Honor.
Okay. I'm not sure if it's in the record, but that's okay. Please continue.
Okay. It's easy enough to see how this happened. The motion judge focused on the type of harm that was caused instead of the type of government activity which caused the harm. As a very quick analogy, imagine you lived in a 2-story house and you came home and found a giant hole in your living room ceiling. You call a carpenter. The carpenter comes over and says, I can fix the hole in the ceiling. But she says the problem is actually the leak from the bathroom upstairs. Under the law, the leak is the cause of action. This motion judge focused on the hole in the ceiling. And because of that, we ask that this erroneous decision be reversed and Mr. Kelly is allowed to proceed with his complaint.
Okay, counsel, you argue that an intentional tort can be committed in a negligent way. As a theoretical matter, I follow that, but what are you alleging occurred in this case? What is the negligence that led to the release of the private information?
The negligence was the failure of Captain Reyes to follow the confidentiality policy. So the confidentiality policy set up the duty of care. And as you can see on the complaint, when anyone was involved with the testing, they were supposed to keep it confidential. And so by failing to follow that duty of care and disclosing this information to the press, it caused damage to Mr. Kelly.
But doesn't it matter how or why he failed to follow that policy? You know, maybe he said, I don't care about the policy, I'm just going to do it. Maybe he forgot about the policy. Maybe he misread the policy. Doesn't it matter for your theory of what happened here?
Well, it was dismissed at such an early stage that there was no factual discovery of the motivation for why he didn't follow the policy. Was he adequately trained? Was he not aware that this applied to him? I mean, at such an early stage of the pleadings, there was no factual indication as to why, but we know it's an error, and negligence covers this type of error. Intentional torts need a different type of intent. And so an intentional invasion of privacy based on a different relationship wasn't in these set of facts, because the government misconduct was based on his failure to follow the duty of care established by the confidentiality policy.
What if instead of converting this claim to an invasion of privacy, as the judge did, what if he had ruled that your complaint sets forth a defamation claim?
So
how would you then distinguish Barrows?
Can you say that again, Your Honor?
How would you distinguish Barrows? I don't know if you're familiar with the Barrows case.
Oh, could you give me more of a hypothetical from that?
Okay, so your complaint, the count for violation of Chapter 258, Section 2, incorporates all the prior paragraphs. And one of those paragraphs, paragraph 49, says the disclosure of plaintiff's name to the media was negligent and defamatory. So the judge here said that this claim for negligence is really a claim for invasion of privacy. Well, what if the judge instead had said the claim as asserted in the complaint is really a claim for defamation? And that Barrows is a case that talks about the tort of defamation and how that sometimes has deliberate or inadvertent conduct, unlike all the other torts listed in 258. So what if this is a claim for defamation, and the judge could the judge have ruled that if your complaint, could the judge have applied qualified immunity if it was a complaint for defamation?
I think whether the harm caused is either defamation or invasion of privacy, you still go back to the original government action which caused the harm. And so it again circles back to the confidentiality policy, which was something that they agreed upon, a duty of care, which they assumed in order to conduct the testing. And as the city acknowledged, that a violation of that caused foreseeable harm. So with your question, whether the harm is defamation as a result of impinging on his professional reputation, or whether it's invasion of privacy, you still have to go back to analyzing the government conduct, very much like Ortiz versus Hampden County, because that was originally, the judge believed, false imprisonment. But the court said you have to go back to what caused the harm, what type of government activity caused the harm. And that was the negligent application of the warrant. So no matter what the result was for damages or harm, you still have to trace it to the government activity.
But doesn't that go back to Judge Milky's initial question, which is the information could have been released by accident or it could have been released intentionally? How does the judge determine that? And does your complaint make a case for why it was negligent and not intentional? because the facts seem to suggest that the department was on some sort of a mission to punish Mr. Kelly. And then you want us to believe, at least as your complaint states, that they negligently released this information, not intentionally. And those seem to be not necessarily consistent.
Well, should we have these type of requirements at this stage of pleadings, then I think you would have a lot more challenges in summary judgment. And pleadings at this stage are not required to rise to the level that you're asking for. So
aren't they required because of Yanakino v. Ford Motor Company? Isn't the requirement higher now than it was at the time of Ortiz?
I actually don't know that, Your Honor. I would have to do some more research on that to answer that accurately. The pleadings met the requirement of what was supposed to move forward in a discovery process. And by changing the matrix from negligence to invasion of privacy and dismissing at such an early phase, Mr. Kelly wasn't allowed to do any type of discovery to move his case along.
But isn't it that you could have drafted the complaint in such a way as to disguise the intentional tort as a negligence claim to avoid the liability?
Judge Blake, the attorney appears to be frozen for the moment.
Oh, not on my, oh, okay.
Yeah.
Is that?
Did you hear my question?
I heard the beginning of it where you were saying the.
So did you dress up an intentional tort as a negligence claim to avoid the liability problem that you now have with the judge's decision?
Well, in drafting the complaint, it was looking at what was the government activity that caused the harm. And so it seems like by really still focusing on the damage, you're overlooking the confidentiality policy, which was the duty of care, which was what the city and Mr. Kelly agreed upon. And so whether that was for, there's no argument that Captain Reyes did it with an intent to harm him. It could have been an error. It could have been an oversight. It could have been something that he said in passing to a reporter. There has been no discovery to figure out the facts of why this error, this accident happened. So if you're asking me in some universe, could you circumvent by changing the complaint? You can adjust the law, but you can't adjust the facts here. And the facts show.
No, but I guess the question is, to what extent does a plaintiff have to plead some specificity with regard to the facts, setting forth the negligence theory, as opposed to in a more conclusory fashion, just saying, well, it's negligent?
Well, I believe that the pleadings established all of the elements of negligence, and even the motion judge found that the duty of care was established. There was, in reading what the government activity was that caused the error, it was the violation of the confidentiality policy. If we take that in a completely out of this universe and this fact pattern, then I could see more of what you're addressing. So imagine that there was no confidentiality policy. Then Mr. Kelly would have to argue that there was an assumed duty of care, that they would protect the information. But that is the linchpin that makes this negligence versus another type of tort, is that there was a duty of care established and then there was a violation of it. So that is what creates the foreseeable harm.
Reporter found out some other way other than through this lieutenant what the list is of police officers who were on administrative leave, and said to, at the press conference, said to the lieutenant, I see that Kelly's on administrative leave. Is that because of the drug policy? Would any response, even if the lieutenant said no comment, would that violate? Would that be defamation? If the press is then going to connect the dots?
Well, it would go back to what was the responsibility outlined in the confidentiality policy. So, I mean, if there was no violation of the confidentiality policy, then I don't believe the city would be responsible under the facts that you say. He said no comment, and then the reporter found it another way, for instance, through the lab that had.
No, if the reporter just inferred from the fact that Kelly is on administrative leave as of a certain date, and that's around the date of the drug testing, the reporter jumped to that conclusion. Does that show negligence on the part of the lieutenant or the police department?
I don't believe so, Your Honor. I believe there has to be an affirmative action which violates the confidentiality policy, which was exactly what happened in this case. But if this was published through other means other than, Captain Reyes's affirmation to the press, then I don't think you do have a claim, because you don't have a violation of the confidentiality policy that the city had agreed to. Any further questions? Thank you for your time.
Thank you very much. We'll hear from Attorney Schneiderman.
Good morning, Your Honors. May it please the court, I am Joseph Schneiderman. I represent the city of Holyoke. I would like to respond to a few questions the panel asked my sister. First, to Justice Blake's question, the appeal was properly before the court. Record Appendix 12, which is the docket sheets, reflects that a final judgment entered on June 9, 2020, after all other claims against the remaining parties were either dismissed or settled, and that's on the preceding page of the Record Appendix, RA 10 and 11. To Justice Grant's, you're welcome, Your Honor. To Justice Grant's question, Officer Kelly is indeed subject to the Iaquino standard, and Ortiz very much predates Iaquino, I think by as much as 25 years, if I'm remembering the dates correctly. So yes, Officer Kelly would have to plausibly plead under and survive and overcome the Iaquino standard. And that leads to my argument, which is, although substance always governs over form, the motion judge was correct to dismiss Officer Kelly's claims at this early stage because neither of the points are sound enough in substance to state a claim against Holyoke, either for an invasion of privacy or for common law negligence. I think Your Honor, Justice Grant actually hit the nail on the head when Your Honor was asking about Barros. Barros at page 627 of the decision notes that General Laws Chapter 258, Section 10C has a representative, all-inclusive list of what the legislature has deemed to be intentional torts for purposes of the Tort Claims Act. And invasion of privacy is expressly listed as one of those torts. I think Your Honor, Justice Grant also hit one of the main points here, which is just defamation and invasion of privacy share a common thread in that the injury occurs without regard to the actor's mindset. The injury is the disclosure or the statement itself. The case law interpreting General Laws Chapter 214, Section 1B, which is the statutory claim for an invasion of privacy, I would submit is very useful here in that although the courts have recognized that this is potentially a broad tort, there are at times compelling counter interests to disclosures, and those counter interests actually become uniquely compelling in this context as to police officers. Indeed, the Supreme Judicial Court has recognized many years ago in Mulgrew versus Taunton, O'Connor versus Police Commissioner of Boston, all of those cases that the public has a compelling right to know that their police officers are able and competent, and indeed, as was pointed out in O'Connor, are not, I'm sorry, Justice Grant?
Why did the judge convert this to invasion of privacy rather than defamation?
Your Honor, I'm
able to do that?
Your Honor, I'm not sure why the motion judge opted to convert that, but we always look to, as I opened with, substance over form, and I think the substance of Officer Kelly's complaint can fairly allege the claim of invasion of privacy. At record appendix.
But isn't invasion of privacy when somebody disseminates something that is true, but the person has a right to have it be kept private? But defamation is when somebody disseminates something that is false. And so isn't the problem here that the lieutenant was allowing or arguably permitting the reporter to infer that Kelly's drug test was positive when it wasn't?
Your Honor, I have two responses. First, I think that reads too much into the record to suggest that it was false. The article, which is appended to the motion to dismiss and reproduced in the record appendix at page 39, points out that Officer Kelly was on administrative leave and that there may have been a problem with the test. There's no suggestion that Officer Kelly himself had used drugs or something along those lines. More to Your Honor's question,
well,
though,
the commenters all took it that way with all those comments about poppy seed bagels.
That's correct, Your Honor. Yes. Your Honor, that actually leads to my second point, which is the SJC's decision in AASH speaks to this, which is in AASH, there was the disclosure of the peer review reports. And then there was information that came out later clarifying the record. And that also occurred here in August after the testing issues had been resolved. Holyoke released new information that Officer Kelly had, in fact, been restored to duty. So I think even though there may have been, the public may have perceived it that Officer Kelly had a drug problem or otherwise, the disclosure was cleared up. And as I suggested before, the public has a very compelling right to know the fitness of police officers and that they themselves are not using the very drugs which they are supposed to safeguard.
What if the police chief had assigned this lieutenant to be in charge of internal affairs and said to him, okay, here's your office. It has no lock on the door and your file cabinet has no lock, but that's okay. You don't need a lock. And then somebody, the cleaning person or somebody, went into the lieutenant's office late at night and photocopied a bunch of internal affairs files and put them up on social media. Would the department be liable for negligence then? Or would qualified immunity apply and say, too bad, anything that happens, it's not our fault?
Your Honor, I think in Your Honor's hypothetical, that would get to the questions of duty which the city has raised in its brief. Certainly, it's not a good idea to not put a lock on a cabinet or on a door with sensitive personnel files. But I think in Your Honor's hypothetical, there would be questions of duty, and there may even be questions about 10J immunity, i.e. whether or not the city was the original cause of that, because Officer Kelly would be injured as a result of the cleaner taking it. So I think it's not an all or nothing, and the middle is that it would raise questions of duty because the public has a compelling right to know about the fitness of the police. And that's also something which I want to clarify. The record here does not indicate that Officer Kelly's medical facts were disclosed. I agree with my sister that those sorts of facts, Officer Kelly's medical status, that should not be disclosed. Officer Kelly has the right to privacy in his medical records. That's not what happened here. What happened here was there was a question about the drug tests themselves. And then once the testing played out, Holyoke then provided additional information, and Officer Kelly was ultimately restored to duty. I think that distinction is critical here, which is the facts that were disseminated were not akin in kind to private facts about Officer Kelly's medical status.
No, failing a drug test is not medical status. That seems to be a bit of a reach.
Your Honor, I appreciate that. I think that's, yes, I could see Your Honor's point there. Certainly the city acknowledges in the brief that drug testing by its terms is a private act. But I think the facts that came out were just different in kind, as I was suggesting to Justice Grant a moment ago. And
No, I understand that argument. You just lost me a bit on the drug test not part of a medical record.
Can I just return to basics here? Your sister's appeal is based on the theory that an intentional tort can be committed in a negligent way. Do you disagree with that statement?
I suppose it could occur that way, Your Honor. Yes, I don't inherently disagree with it.
So, and isn't it, at least putting aside how this issue was pled in the complaint, isn't it theoretically possible that maybe it's not the lock on the door, but that it was, that the information here was released because of negligence by the department?
Your Honor, if it is indeed negligence, that actually takes me to my second point, which is this is not an injury which negligence is supposed to redress, because recognizing a duty of care here has potential to end run the key compensation schemes available to police officers, such as collective bargaining, such as the civil service law, and such as line of duty injury benefits. I think if Officer Kelly's point goes beyond this preliminary juncture, and the points are very well taken, we are on a motion to dismiss. We assume the facts in Officer Kelly's favor in the light most favorable to him. The problem is that Officer Kelly is still asking to overlay common law negligence liability over a very exhaustive set of statutes. And I think that sea change is problematic. It's very problematic because first of all, it's at odds with the Tort Claims Act. The Tort Claims Act narrowly limits how and when a city like Holyoke may be sued and who may sue them. It's at odds with the law about police officers. As this court and the Supreme Judicial Court have recognized for a long time, we like collective bargaining. Collective bargaining puts people at arm's length, and they can bargain about the conditions. Indeed, Officer Kelly, the confidentiality provisions here stemmed from collective bargaining. We have the Civil Service Act, which provides for back pay for erroneous discipline. We have line of duty injury benefits, and we've recognized that you can't recover both line of duty injury benefits and Tort Claims Act damages. I think permitting this to proceed would not be sound public policy because it has grave potential to interfere with all of these elaborate schemes which potentially offer, it's a tongue twister, Officer Kelly some form of additional redress. And I think in that light, the motion judge would have been correct to dismiss it now because duty is a pure question of law. I would just end on this note, unless there are further questions. The motion judge was correct, regardless of how this complaint is pled, framed, or read, to look at it to determine whether or not Officer Kelly had plausibly stated any claim for relief. Indeed, that actually predates Iacchino. The question on a motion to dismiss is, has the pleader pled any form of relief? The motion judge here was correct, whether it's viewed as invasion of privacy, defamation, or common law negligence, to conclude that the four corners of this complaint did not allege facts which could either overcome Tort Claims Act immunity or that there was a duty of care here, because recognizing a duty of care would not comport with the many statutes and case law governing the compensation of police officers, the structure of police departments, and their benefits. I ask that this court affirm, and I thank you kindly for your time.
I just want to check with my colleagues to see if they have nothing else. Thank you both very much.